Companies Act Section 74. Repayment of deposits accepted before commencement of this Act. Introduction to Section 74. Section 74 of the Companies Act addresses the obligations of companies concerning deposits that were accepted prior to the commencement of the Act. This section is critical as it ensures that companies are held accountable for the repayment of deposits and accrued interest, even if the deposits were accepted under the previous regulatory framework. The provisions outlined in this section aim to protect the interests of depositors and establish clear guidelines for the repayment process, thereby enhancing the financial integrity of companies operating within the jurisdiction of the Act. Key provisions of Section 74. 1. Obligation to report unpaid deposits. Filing requirement. Companies that have accepted deposits before the commencement of the Act are required to take immediate action if any amount of such deposits or interest remains unpaid at the time the Act comes into force, or if any payment becomes due subsequently. Specifically, the company must file a statement with the registrar within 3 months from the commencement of the Act or from the date the payments become due. This statement must detail all deposits accepted by the company, the amounts remaining unpaid, and the interest payable on those amounts. Additionally, it should outline the arrangements made for the repayment of these deposits. Compliance with existing laws. The requirement to file this statement is mandated irrespective of any existing laws or the terms under which the deposits were originally accepted. This provision ensures that companies cannot evade their obligations by citing prior agreements or schemes that may not align with the new regulatory framework. 2. Time frame for repayment. Repayment deadline. The company must repay the unpaid deposits and any accrued interest within 3 years from the commencement of the Act or before the expiration of the period for which the deposits were accepted, whichever comes first. This provision is essential as it establishes a clear timeline for repayment, ensuring that depositors are not left in uncertainty regarding the return of their funds. Renewal of deposits. Any renewal of these deposits must be conducted in accordance with the provisions set forth in Chapter 5 of the Companies Act and the relevant rules established therein. This stipulation reinforces the necessity for companies to adhere to the regulatory framework when managing existing deposits. 3. Tribunal's authority to extend repayment time. Application for extension. Companies that may face difficulties in repaying the deposits within the stipulated time frame have the option to apply to the tribunal for an extension. The tribunal, upon reviewing the financial condition of the company, the amount of deposits, the interest payable, and other relevant factors, may grant additional time for repayment. This provision acknowledges that companies may encounter genuine financial challenges and provides a mechanism for them to seek relief. 4. Penalties for non-compliance. Consequences of default. Should a company fail to repay the deposits or any interest due within the specified time frame, including any extensions granted by the tribunal, it will face significant penalties. The company will be liable for a fine ranging from a minimum of 1 crore rupees to a maximum of 10 crore rupees. This establishes a stringent penalty framework to deter companies from neglecting their repayment obligations. Liabilities for officers. Furthermore, every officer of the company who is found to be in default regarding the repayment will also face severe repercussions. Such officers may be subject to imprisonment for a term that could extend up to 7 years, or they may incur a fine ranging from a minimum of 25 lakh rupees to a maximum of 2 crore rupees, or both. This provision underscores the accountability of company officials in safeguarding the interests of depositors and adhering to regulatory requirements.